and many others, and hopefully you'll hear from a handful of them. This, of course, flows from the Kelo versus New London, Connecticut case. It is an effort to place in the Constitution the protections that the United States Supreme Court invited states across the country in Kelo to insert in their constitutions. Of course, right now we have state law that does an adequate job of protecting property rights against condemnations for economic revenue generation, jobs, private financial gain. However, of course, that is subject to the whim of any General Assembly, and even since 2009, when the legislation was adopted, or 2008, there have been efforts to water down our statutory protections. And of course, we didn't get to the point where we were in 2007, 2008 with a virtually useless set of statutory protections that allowed essentially local governments and government to take property for virtually any reason whatsoever. We didn't get to that overnight. We got to it over the course of a century of incremental chipping away of these fundamental property rights that we have. And we're not going to get back to that point overnight. But we've already seen signs that there are efforts to start chipping away at those property right protections. This places in the Constitution of Virginia those protections and ensures that the people of the Commonwealth are the only people who can speak up and surrender those rights. Property rights does belong in the Constitution.
And property rights is in the Constitution, Section 11 already, but I ask you, what does this do that state law doesn't currently provide?
It prohibits and prevents 51% of the members of the General Assembly from incrementally chipping away at property rights, which is the natural course of human events. Liberty, once lost, is seldom regained. This is a historic opportunity for members of the General Assembly to restore property rights.
What in this language, though, is different from existing law?
This embodied places in the, well, right now, existing law permits you and I to muster a majority of the General Assembly to wipe out those property right protections. That is changed through this.
That's the substantive change.
That is.
Okay.
This does not break new ground. You are not treading out on a thin limb.
The chipping away you talked about, is that occurring in Virginia?
Yes, it is. There have been pieces of legislation that have already been offered only a couple of years after the adoption of our protections. And with each passing year, it becomes more of a distant memory, and efforts to chip away at those protections are going to become more prevalent.
Mr. Chairman,
Senator
to
Keisha.
follow up on those efforts to chip away, have any of those pieces of legislation passed?
Not yet. And I respectfully submit that back in 2005, when the U.S. Supreme Court decided Kelo, there was a groundswell of support. Unlike, it was a very unusual experience. Democrats, Republicans, liberals, conservatives, all linked arms and said, "This is outrageous." I've seldom seen that kind of a consensus form around a decision of the U.S. Supreme Court. And this is the reaction to that, and this is the final chapter in trying to come together to accept the invitation of the U.S. Supreme Court to do this.
And I'll tell you, Senator, I hear from my constituents often they're concerned about eminent domain abuse, primarily from the Commonwealth of Virginia for road construction or from utilities. And I remember Farm Bureau dinner with you, probably in Augusta County 5 or 6 years ago, and you said there are 3 instances where eminent domain abuse occurs: the Commonwealth of Virginia for road construction, utilities, and housing authorities. And I look at this language, and I know the limitations of the bill we passed before, and that was an imperfect bill. But look at this language, and on line 30 you exempt public transportation facilities, and on line 33 through 36 you exempt public utilities. So this is just aimed at housing authorities, is that accurate?
No, it's not. And let me just make a comment with great affection and respect to the chairman of the subcommittee. Get your own bill. I invite it, and I think that those are worthy endeavors to look at. However, this is a narrow reaction to the decision of the United States Supreme Court in Kelo. It does not endeavor to do anything except prevent the kinds of takings that are for private economic gain, taking your property or mine by government because they think that somebody else can use it better. Right now, at least under the law as it was, we basically have property on loan from the government. It wasn't ours. Our property rights meant very little. If our local government on a whim decided that a box store could generate more revenue, more jobs, the heck with the fact that I own it.
Now, where does that happen in Virginia?
I'll tell you, it happened in Hampton, for example. Great store, that Bass Pro Shop to the right off of Interstate 64 was one of the seminal decisions in Virginia dealing with property rights. They condemned that property so that they nominally, I mean, they said they were taking it for an exit off of the road there, and there was a fight over whether they needed all of the property, something like 70 acres, and they said, well, we do. And the property owner said, you can't take it for that. And they took it and conveyed it, of course, to the private developer.
Mr. Chairman?
Senator Waters.
Yeah, I'd also like to say that while there may have not been as many instances to be recounted, there's certainly the opportunity for cities to do that. I've been personally involved in situations where cities use that threat, end up purchasing the property, keep private investors from acquiring the property. So there's always that opportunity that can be exercised, and that has a chilling effect on business, on those property owners.
I just suggest that in rural areas, if the local government tried to do this, they wouldn't be local government very long. It wouldn't happen.
Well, there are examples of it happening throughout Virginia. I mean, of course, you've got the case in Roanoke involving
That was downtown too.
Yeah, that's right, a local healthcare institution. Of course, that started before the reform took place, and my understanding is that there may be something brewing in Norfolk right now that may be perking up. So,
Do you have something else you'd like to say, or ready to hear from
Mr. Chairman, members of the committee, I just would ask you to look kindly upon this good measure and hear from folks who are here to speak in favor and oppose.
Are there those who would like to speak in favor of the bill?
Thank you, Mr. Chairman, members of the committee. Trey Davis with Farm Bureau, and we're asking you again to support Senator Oberstein's legislation. We were proud specifically of the Senate in 2007 in passing those statutory changes that if you were taking a landowner's property, taking a landowner's farm in that unfortunate situation, that it is not going to another private entity to raise the tax base to increase employment. We're proud of you then. We're asking to just ensure that'll be here for as long as possible by to the Constitution. Thank you.
Mr. Chairman, members of the subcommittee, Katie Frazier with the Virginia Agribusiness Council. We join Farm Bureau in supporting this good measure. We've come to you before in support of a constitutional amendment for this, but you'll note that our membership does not come to you asking willy-nilly to amend the Constitution. But private property rights are something that our members hold dear, and it is actually the property that is the basis of our businesses. I know that you've asked about rural areas, and I'll note that in our membership, it's not just the farms and that land, but it is also rural agribusinesses, some of which are not always located in a rural area. A Southern States feed store, a supply store might actually be in a downtown area that would be condemned. And across the board, our membership really feels that private property rights are critically important. The other point that I wanted to point out in this legislation, as is in the law that was passed, that it does say that no more private property shall be taken than is necessary for the public use. So that does ratchet down on some of the instances that I think you, Mr. Chairman, hear about from your constituents as far as concerns about state agencies taking more property than perhaps what is needed. So we would appreciate your support on this measure. Thank you.
Thank you. Who's next?
Ladies and gentlemen, my name is Sam Capilani on behalf of NFIB. I'd like to echo what Virginia Agribusiness and Farm Bureau said. NFIB has a long history of supporting the protections on private property rights, and we'd like to extend our support for Senator Obenchain as well as this bill. Thank you.
Thank you. Who's next?
I'll be brief. Julia Carlo Hammond on behalf of the Governor's Office for the reasons articulated wonderfully by Senator Obenchain and also the Virginia Farm Bureau, the Virginia Agribusiness Council, and the National Federation of Independent Business. We support the Senator's legislation.
Thank you. Are there others? Are there those who would like to speak in opposition?
Mr. Chair, members of the committee, Randy Cook, representing VACO and VNL. We take the position that a constitutional amendment is premature at this point in time. As the Senator said, he passed the statute in 2007. To date, there's not been a Supreme Court case to interpret that statute that defined public use. There's plenty of time for the General Assembly to react to a court case once we have a court case. We think that the court should interpret what you did in 2007 if needed, and then you can react. This puts into the Constitution what you already have into the statute and doesn't go a step beyond that other than you're protecting yourself from yourselves, in essence. We took a seat at the table when you rewrote the statute in 2007. To my knowledge, local governments certainly have not been chipping away at what you did in 2007. We are scared to death to chip away at the definition of public use. We just simply wouldn't do it. The cases cited by the Senator, the Roanoke case obviously was filed prior to the 2007 statute, which he said the Autofero case in Norfolk was ruled on by the Virginia Supreme Court and approved. So the court approved what was done in Autofero, and without opening that case up, the plaintiff in that case said that the property was 95% damaged. So that's why all the property was taken. And the court agreed with the local government in that case. But we don't need to argue Autofero. We just think that it's premature to do this, and let's let the dust settle. I think there are others who would like to speak.
Are there others?
Good morning, Mr. Chairman, members of the committee. My name is Karen Harwood on behalf of Fairfax County. I have to echo what Randy just said, but then add that just directing the committee's attention to lines 28 and 29, by putting in the Constitution that no more private property may be taken than necessary to achieve the stated public use, will elevate to a constitutional issue things like how wide is our sanitary sewer easement. If we have an integrated sanitary sewer system where the standard sanitary sewer easement, for example, is 20 feet wide, well, this would give a landowner the right to come up and say, you can do it in 18 feet. You can do it in 17 feet, and I've got a constitutional right to make it. And it's very disjointed on linear projects.
I'm sorry, but that's the part of the bill I like.
Well, okay, I'll sit down.
Are there others?
Mr. Chairman, Kelly Harris Braxton with Virginia First Cities Coalition, and I just wanted to echo the comments of Virginia Municipal League and VACO. We believe that there are no abuses. There have been no abuses since 2007, and that there's really no need to put this in the Constitution. And again, we don't know of any efforts to chip away at the language.
Okay. Are there others? And I'm sorry I didn't ask if any member of the committee has a question, a burning question for any folks attending. Okay, the bill before you.
Mr. Chairman, if I could just close very briefly. I appreciate the comments of the supporters, and I hear again the comments of the opponents. What you don't see this year is a broad coalition that has been here in years past. I think that on eminent domain reform, the horse has left the barn. We are well on the way to reforming and permanently placing in the law of Virginia these reforms. Ms. Harris-Braxton said there have been no abuses since 2007. Well, I don't know whether that's true or not, and I also heard that I heard VACO say essentially, "Stop me before I condemn again." This is an important protection. We are protecting the people of Virginia against arbitrary legislative action and incremental infringement upon these constitutional rights. It is an important step that needs to be taken, and it needs to be taken now.
Okay, bills before you.
Move to recommend for
Second.
We've got a move and a second that the bill be reported. Any discussion? All in favor, say aye.
Aye.
Opposed, no?
No.
Okay. Yeah, Mary Margaret's, we have our proxy, so she's a no, so it's three yeses, 4 noes.
And that's
Unless you want to do roll call.
clerk reporting that. That's the clerk.
Just call roll.
Senator Martin,
Yes.
Senator Deeds,
No.
Senator Whipple,
No.
Senator McEachin,
No.
Senator Smith,
Yes.
Senator Northam,
No.
Senator McWaters.
Yes.
Okay, do you want to reverse that and make a motion with PBI?
Yes.
Mr. Chairman, that's to recommend PBI.
Is that motion?
No, is it recommended the way the chair is handling it? Is it still recommended?
That's up to the chair.
Any motion?
The chair.
Move to recommend PBI.
Second.
Just reverse the vote on that, 4 to 3.
Mr. Chairman,
Thank you.
members of the committee, I appreciate the courtesy.
Thank you.
Thank you.